Now what we'd like to do is move into the next talk, and this is legal and policy. Paula Neira was supposed to be here, but she is ill and unable to travel, but she's here with us on Zoom. And unfortunately, Lee Nevins is ill, and they won't be able to join us as well. So welcome to Paula, and please go ahead, Paula. Welcome.
Folks, hi, Gail. Thanks so much for the team for giving me the chance to be there. I really was looking forward to being there with you in Montreal, and then after 2.5 years, COVID finally caught me. So I'm sitting at home in Bowie recuperating. So I know that we're doing this at a distance, and I really want to make this as interactive as I can from a distance. So I'm going to go through the slide decks, but I really do want to encourage folks to share their perspectives, because when we talk about the legal issues and policy, there are many different perspectives that are being involved in this. And I'm sure that there are some folks up in the room that also, like myself, are lawyers involved in this space and are involved in the work. And then also many of the healthcare providers providing information into policymaking or testifying as expert witnesses in cases and being involved in this process. And that's the perspective I'm going to take it from. And I particularly encourage those from, who are coming to the conference from outside of the United States to please share, because much of what I say may be very US centric, and we want to keep in mind that this is these are global challenges. So so we look at 2022, and this is within the United States, and actually the slide is already out of date, because I was at a brief earlier this week, and that number now is not 300, it's now 330. So think about it, an increase of 10% since the slide was made. Numerous states have either engaged in having litigation and legislation proposed, or the government has taken actions that are targeting the LGBTQ plus community broadly. And then at least half of these bills are specifically targeting transgender people, particularly transgender youth. Now, the way that these bills are being played out is, one is attempts to ban gender affirming care. That's an action that's taken in Florida. In Alabama, they're trying to criminalize by making it a felony to provide gender affirming care to transgender youth. And the bill is called the Alabama Child Compassion and Protection Act. So, the height of cynicism and hypocrisy. Or these bills are trying to bar the use of facilities aligned with gender identity, or to bar participation in interscholastic sports aligned with gender identity. In the case of Kansas, that act is targeted at one school-aged girl. There is only one transgender girl participating in interscholastic athletics in Kansas. That's the level of focus that the opposition is putting on having transgender people seen in our society. In Texas, just this week, a judge in Texas expanded her order barring the governor and the attorney general from using child protective services who have been instructed to investigate supportive families for suspected child abuse. So this is what's going on in the United States, across the states. And the what happens is, if these bills are signed into law, they're immediately challenged in court, and right now they're all enjoined. So there's various stages of litigation that are going on depending on what state you're talking about. And depending on the very specifics of that situation, it's either being played out in state court or it's being played out in federal court. Looking at it globally, I've broken this up into the good, the bad, and the ugly. The ugly is very straightforward. In 13 countries, being transgender is a crime, either in a de facto way because of the way that other laws have been implemented, or de jure. It just says it in the law. And in countries you know, in the Gambia, Malawi, Nigeria, and South Sudan, it's actually in the law. In the other countries, it's the implementation of the laws. But the picture isn't completely bleak. You know, there have been advancements and there is some progress. You know, globally, there are options now to remove the gender marker from government ID completely and remove that situation where people get harassed or discriminated against because their government issued identification doesn't match who they are. There's an increase in legal gender recognition by self-determination, removing some of that artificial criteria before the state will recognize an individual's gender. There have been some court victories. And in some places like Uruguay and Ecuador, the recognition that past injustice and discrimination should merit some type of reparation. In Uruguay, it's by regulation. In Ecuador, it's trying to achieve that through civil rights litigation. When I say the bad is really a mix of making some progress or fighting against regression from past progress, or it's just stalled out. And as you can see on the slide, it's going to vary by what region of the world you're talking about. In some places, you know, there are still great challenges. In Japan, you know, their highest court still held that in order for the state to legally recognize your gender, you have to have some type of procedure which involves sterilization. So basically, unless you have bottom surgery, the state's not going to allow you to change your gender marker. You know, that needs to change. You also have countries such as Bulgaria and Hungary, where there are efforts to completely remove legal recognition for transgender people. And you have countries like Poland and Russia, which are using the LGBTQ plus community broadly, but then specifically talking about transgender folks as political pawns to push political agendas. But the notion of in Poland that you have LGBT plus free zones, and the rhetoric from Russia, and in part that rhetoric being used to justify the war in Ukraine because of, so, you know, the alignment with the West and Western values. That's what's going on a global status. Okay. All right. So in talking about legal recognition, and break this up into a couple of components. So, and this is, you know, much more of a US focus. So within the United States, you know, changing, oh, need to go back one, skipped over a slide. Oh, back one. Should be name. There we go. So being able to update your name on your government issued ID. Generally, post 9/11, this has become more of a challenge because of the, you know, the perception of of heightened security and making things a little bit more of a challenge. The actual requirements to do it vary by jurisdiction. And, you know, I would refer folks to the National Center for Transgender Equality. On their website, they have a web page where you can type in what state you're looking for, and it'll give you the most updated information they have on what are the requirements for a name change in that state. Now, within the military, you know, the DD-214 is the document that a veteran gets at the end of their their active military service. Historically, the government has just viewed it as a piece of historical paper, documents that you did serve. But that's not how that document is used in real life. And the legal implications for transgender veterans in real life is that that document has to be shown to almost any employer. because employers know that if you were in the military, you should have one of these, and it lists what type of discharge you have. And depending on what year you served in, if you were outed because of your sexual orientation or your gender identity, you may not have a fully honorable discharge, again, because of the animus of the time. Also, that document needs to be shown when you apply for government programs for any type of veterans preference that you have, or your eligibility for veterans programs, such as something as simple as getting a VA housing loan. And most of us have gendered names. So your gender marker is not on a DD-214, but you're open to the discrimination simply because of your name. The military can't change those documents on their own volition. The veteran or the veteran's family has to make a request through either the Board for the Correction of Military Records or the Board for the Correction of Naval Records, depending on what service you were in. And the jurisdiction of those boards is based on error or injustice. Rarely is error going to be an issue. It's more going to be that the veteran has to argue an injustice, and arguing that by having this gendered name on this document when you've changed your name opens you up to discrimination is an injustice that the government will recognize. And because there is a statute of limitations just for those who want to do this, if they've been out of the service for a while, you just need to address in your petition why the statute of limitation shouldn't apply. I was fortunate. I'm the first Navy veteran to have my DD-214 updated with my correct name. The National LGBT Bar Association, some pro bono law firms, and myself were able to do that. And I did it at the same time with two other Army veterans who were able to achieve the same thing from the Army's Board of Correction for Military Records. So the precedent's been set, it's there. An organization called the Transgender American Veterans Association has a guidebook, and I would tell veterans that are interested in having their DD-214 updated to go look at that guidebook and engage in the process. So now, changing the gender or sex marker on documents, again, varies by jurisdiction. Some states will let you do this, some states still will not. And there are court cases that are challenging those discriminatory practices. Some states are also now recognizing an X gender marker to reflect for non-binary folks. On your passport, the US State Department, as of this past April, will now issue a passport with an X gender marker. And for folks that are wondering where the X comes from, that's the designation on the International Air Travel Standards. So that's why it's an X as opposed to NB or something else. Now, for updating your Social Security documents, your birth certificate, again, requires a process that often requires interaction with the legal system to get a legal name change. Now, for things like bank accounts, payroll, ownership records, payroll, most organizations will have to use your legal name on payroll because it deals with interacting with the federal or state institutions for the collection of taxes. So that's why, like on a W-9, you're going to see a legal name used. For bank accounts, Visa cards, those types of things, it may vary by institution. Some institutions are more inclusive and will issue a credit card with a chosen name on it, for example. Others still insist on a legal name. When it comes to school records, you should be able to use a chosen name or an affirmed name on your school ID card or on your diploma. Those are things that are absolutely within the control of the institution. Some institutions are ahead of others. I can tell you, I know at Johns Hopkins University and Johns Hopkins Medicine, earlier this year, we went through our policies, so we allow the use of a chosen or affirmed name in our student systems. Understand that none of these systems were ever set up with transgender people in mind. So the interfaces between many of the systems in an organization, you may change it in one place, but it still may not have been changed in another. And it takes some sleuthing and tracking down. So be aware that that can happen. Generally, when you're talking about professional licensure and board certifications and school official transcripts, those are still going to likely require to use a legal name. Now, for legal recognition of marriage in the United States, with marriage equality now being the law, that provides some protection and mitigates some risk. But someone's gender identity absolutely becomes into discussion. You know, it can be used wrongfully in divorce cases, in child custody cases, in putting the appropriate name on a child's birth certificate. Are just some of the examples of where this comes up. Right. When we talk about adverse discrimination, a landmark case was obviously the Supreme Court's decision in Bostock versus Clayton County. That was the first time the Supreme Court ever held that the civil rights laws in the United States apply to gay and trans people, and I'm using gay and trans as umbrella terms, as a form of sex discrimination. But that case is a Title VII case, and the way the civil rights laws are in the United States, Title VII deals with employment, Title IX deals with things like healthcare and public accommodations. And just because that ruling was in Title VII doesn't mean it automatically applies to Title IX. Now, that's the way the current administration is interpreting it. And I personally, so there's no doubt, I agree with that interpretation. It should be consistent in the law. But as a lawyer, now putting on my lawyer hat, you would argue that Title VII and Title IX, two different things. It needs to be argued and make sure that it applies in Title IX. Now, in June of this year, an executive order was put forth by the White House directing the federal agencies to look at their programs to reduce discrimination on the basis of sexual orientation and gender identity. There is a proposed rule, which right now is open for public comment. That public comment period ends October 3rd, that has the implementing rules for Section 1557 of the Affordable Care Act. 1557 is the non-discrimination section of the Affordable Care Act. It takes the Bostock ruling and puts it into effect within healthcare. That when we say that sex discrimination is impermissible, that means including discrimination on the basis of sexual orientation or gender identity. Now, understand, this is a little bit of quick background. When the Affordable Care Act was originally passed in 2016, though the original rules that had that interpretation, the day before they were to be implemented, were enjoined in federal district court in North Texas. So they were never implemented at the federal level. In 2020, the Trump administration tried to impose their set of rules, which obviously removed all of the protection for LGBTQ plus people. That interpretation went to court and is still in court. None of the implementing regulations for this section of the Affordable Care Act have ever gone into effect, because as soon as the proposed rule is announced, once there's litigation that ensues and it's been enjoined. And my legal crystal ball is that the same thing's going to happen later this year. Now, for housing and public accommodations, again, we now have an executive order directing the federal agencies like Housing and Urban Development to look at their regulations and rules to remove discrimination against folks. Obviously, under the previous administration, Housing and Urban Development was perfectly okay with rules that would have allowed homeless shelters to deny access to people based on their gender identity. Okay, that's no longer the case. But this is not settled law. When we look specifically about healthcare, Section 1557 makes it impermissible to have general exclusions on gender affirming care in insurance policies. It makes that impermissible discrimination. There are still insurance policies that have blanket exclusions for gender affirming care. Was notified of a situation in Illinois earlier this week where someone needs to get hormones and their insurer says, nope, it's not even a covered benefit. So these are ongoing fights where if it happens, as healthcare providers, we get involved in the appeals process and peer-to-peer review process for when there are denials, when it's arguably a covered benefit. If it's specifically excluded, that's an issue that has to go to the state insurance regulators if it's a state regulated insurance plan. So again, this is an ongoing challenge, and you don't need me to sit here and tell you folks that. This is part of our ongoing daily challenges we face. Now, lack of trained specialists and providers. The amount of time that is spent on LGBTQ plus health broadly and in transgender health specifically is minuscule in most schoolhouse programs. For disclosure, along with Gail, I worked on the education chapter, and we're going to say the basic same thing. We need to do education. So there are efforts to try to get this education into school curricula, to get it into orientation programs, to get it into continuing education programs. But that's going to be glacial. That's not something that's going to happen overnight. That's a slow, very frustrating process. The other thing I'll say about trained specialist providers, and I say this in the context of, we want, the voice of the community to be involved in training those who are going to be providing gender affirming care. And that's an absolute necessity. But one of the things that as a community, in looking at how do we address this, it's the reality that most of the people that are going to be providing gender affirming care in the near future are not transgender people. They're going to be cisgender. Most of them are probably going to be heterosexual. And our challenge is to make sure that we get this training to everybody and not just rely on the day when there are more transgender or gender diverse people providing transgender healthcare. And that fear of ridicule, rejection, and violence, since these slides were put together, I'm going to modify what I was going to say about this. First of all, is obviously from the patient perspective. There is well-documented history of the discrimination and harassment that people have faced trying to access healthcare globally. This isn't an American problem. This is a universal problem. And we still need to address this. We still need to reduce that willful ignorance, that prejudice, that bias that many healthcare providers still have about providing care. So that, when someone comes to seek healthcare, whether it's for gender affirmation or just general healthcare, that they're able to do so free of a fear of being discriminated against because of who they are. Now, the piece that I'm going to add that I didn't contemplate when I was originally asked to look at this is that now you are also seeing threats directed at the providers of gender affirming care. In the media, you can see the reports about the attacks on Boston Children's. You can see attacks that were made at Children's National in Washington. This isn't going to end. I expect more programs and more individuals to be targeted. And that, is going to deter organizations from providing the care. Or they'll provide the care, but it's going to be done under the radar. And it's not going to be publicized, which means someone in the public looking for the services is going to have a harder time trying to find them. So that's going to be more reliance on community-based word of mouth support networks to be able to get that word out, as opposed to just using, regular media, regular communications channels. Again, for social services, when we look at housing, the 2015 U.S. Trans Survey is the largest survey so far to date. That survey, the 2022 version, I believe, is still on track to be conducted later this year. But 30% of transgender respondents experienced homelessness at some point in their life. And within the year before that was done, of those who did experience homelessness, 85% didn't seek shelter because of that real fear of being discriminated against or being targeted for violence. And then of the ones who did seek shelter, you can see the numbers. Slightly less than half were either mistreated or denied access. When we talk about disability coverage, the Americans with Disability Act, when it was originally written, made very clear that being transgender is not a disability. And it talked about gender identity disorder. Well, a recent decision in the Fourth Circuit has held that those who are experiencing gender dysphoria are protected under the Affordable Care Act. And it makes the distinction between dealing with gender dysphoria, a medical condition, and your status as being transgender. This is the only circuit so far that's made a ruling like this. As cases progress through the other circuits, we'll see what happens. If other circuits rule in a different way, that's the situation where you have different circuits interpreting the law differently. Those are the kind of cases that should be going up to the Supreme Court. When we look at immigration, approximately 50,000, undocumented transgender immigrants, and notice that data is about a decade old. There is guidance that's out there that the appropriate care is supposed to be provided to detainees, but it wasn't made mandatory. And when making an asylum request, it can take years to adjudicate that request. 2021 was the worst year on record. The trends, continue to be bad. I mean, the absolute numbers, the last ones I looked at earlier this week, there might be slightly less than last year, but that doesn't mean to say that it's good. It just means to say that the reporting may not be complete. The most recent study shows that transgender folks are victims 4 times more likely than a cisgender person. And layered onto that is the continued wariness of interacting with law enforcement because of being victimized by law enforcement and targeted by law enforcement because of one's gender identity. The other thing that plays into the levels of reported violence against the community is, the misgendering that happens through law enforcement, through the media, when the victim is transgender or gender diverse. So that impacts the ability to really have a sense of what those numbers actually look like. When we talk about transgender folks in government custody, the Prison Rape Elimination Act was implemented in 2012, and it's supposed to provide for an individualized assessment for housing and safety. And it's supposed to happen every 6 months. But overwhelmingly, those who are transgender are not housed aligned with their gender identity. A NBC News study report had that out of about slightly less than 5,000 inmates that they were able to track, only 15 were housed in accordance with their gender identity. So, again, very discouraging news. Those housing decisions are getting challenged in court. But again, litigation is a slow process. The guidance is that transgender folks who are incarcerated should have access to clothing aligned with their gender identity, and they should have access to gender affirming medical treatments. One of the things that, in the conversations around providing care to those who are incarcerated, there are some folks in the transgender community who says, hey, why should those folks, again, the trying to other people in our own community, say, why should they get access to care when I can't get access to care? Well, in the United States, the answer is real simple. The 8th Amendment of the Constitution, which prohibits the government from inflicting cruel and unusual punishment, and denying people medically necessary care is cruel punishment. It's as simple as that. Now, the arguments are always around that gender affirming care is medically necessary care. States and municipalities that don't want to provide the care, that's what they fight about. The other problem that comes up are some jurisdictions have what are called freeze frame policies, which means that unless you had started some type of gender affirming treatment before being incarcerated, they were not going to start or initiate things like hormone therapy while you're in state custody. And again, these policies are being changed because, you know, you know, an analogous healthcare argument is you wouldn't make the argument that, well, we're not going to take care of your now present medically necessary healthcare needs because you didn't have it the day that you were, placed in incarceration. Well, transgender healthcare shouldn't be treated any differently. So change the slide. This isn't tomorrow. These are challenges that are happening right now that have been ongoing. Again, we talked about health insurance and the barriers to healthcare delivery. We cannot get around the conversation about religiosity and politics and the impact this has on transgender health. Not just transgender healthcare, but all of the policies that impact the social determinants of health. And the battlefield is going to be on the issue of religious liberty, because that is the argument that is used by those who want to be exempt from non-discrimination legislation that benefits providing care and services to the transgender community. Nationalism, and in the United States, particularly Christian nationalism, is what is behind this slew of state-based legislation. It's the alliance for partisan political reasons, with organizations that profess to be Christian, but are in fact anti-LGBTQ hate groups as labeled by the Southern Poverty Law Center, putting together to try to impose a particular worldview that does not include the transgender community in it. And we're playing defense. There are some areas of progress, but mostly it's trying to maintain and protect the advancements that have been made. And while the situation still needs lots and lots and lots of work, being intellectually honest, there has been some progress. The world is different than the 40 years that I've been an adult in the adult world. But we've got a lot of work to go to protect what's been the advancements that have been made, and then to continue to try to make progress. And these are some of the primary resources. And with that, I'm going to stop talking and see what questions people have, or other perspectives that folks there in the audience would care to share.
Hi, Paula, it's Gail. Thanks for joining us and making that huge effort and continue to speak, which is it's always fantastic to hear you. Can you just briefly talk about the first two recommendations for the Standards of Care chapter, the education chapter, because I know that you were involved in drafting them, and I think people would like to hear that, because that's part of that really good legal policy.
You're going to catch me for a second, is I don't have them right to hand.
Okay. The one about that all institutions should provide, yeah.
Okay. In general terms, and like I said,
Yeah.
don't have it right in front of me. Basically, the recommendations say that, within healthcare providers and all levels of healthcare staff should have training and education on how to appropriately take care of transgender people. And that's from a cultural perspective, that cultural awareness and the basic competency to be able to treat people with dignity and respect. And then for those in the various specialties, to have those specialties develop the specific competencies to be able to say, this is clinically competent gender affirming care. The recommendation for non-healthcare, the governmental agencies, the non-governmental organizations, basically any of the organizations that interact with the transgender community, their staffs also need that cultural awareness training, because those, the policies that are developed that people don't automatically associate with healthcare, housing policy, employment policy, banking policies have impacts on those social determinants of health. So that recommendation is that all of those organizations need to provide that training to their staffs. So when their staffs are developing policies, when they're working with, procedures and situations that are going to have an impact on transgender health and the transgender community, that they have had this training so that it's an awareness that when they do their work, they take this into account. And like I said, historically, none of our structures were ever set up, with transgender and gender diverse people in mind. And it's always a challenge when you ask a lawyer to say something briefly about that.
I thought that was a great summary. Josh has a question for you.
Yeah, that was an amazing talk. Thank you very much. My question really relates to the intersection of law, policy, and medicine. This is coming from that 4th District case with the ADA finding, where we in the medical world are evolving in how we characterize transgender people in some of our interventions. And so it struck me as interesting that gender dysphoria, which is still a very mental health framing term that we're actually getting rid of in ICD-11 when it comes out in 15 years, is okay, but being is protected, and being transgender is not. And I wonder, does that make you nervous, or should we be nervous in terms, when we're framing being transgender and using other diagnostic codes, for example, because we're thinking of just trying to medically intervene and not have it a mental health lens?
Yeah, I mean, the ongoing danger of stigmatization is there. But I think this is something that we're, the navigation of the policies and the laws of how we're going to navigate this to the benefit of our people. And, and also, the arguments that are sometimes made by lawyers for the benefit of their client are not necessarily those that benefit the entire community. And the example I'm going to use isn't the Fourth Circuit one, which I don't know all the details of, is the argument that was made by Chelsea Manning's lawyers that somehow her being a transgender person impacted her decision-making when she, in the military. And, her being transgender had nothing to do with, betraying, her oath and, her duties as a soldier. But that was an argument that was made by her attorneys trying to represent their client, even though it had negative impacts on, the broader community and the broader advancement for community issues. Here is you're trying to navigate where you obviously don't want to say that you just simply being you is a disability. That's why you can't say, being transgender is a disability. Just as being transgender is not a mental illness, it's not a disability. But the condition that, and the way we frame this, whether yes, in ICD-11, we should be talking about gender incongruence under sexual health and not under mental health, is if the court says that, wait a second, this situation, because you are dealing with this condition, opens you up to unfair discrimination, you now have protections under this act. That's probably a good thing. One of the other things about where this tension between just talking about transgender people and talking about gender dysphoria is an understanding in the Trump administration's attempt to reimpose the ban on transgender military service. And I don't mean to be pointing at people, sorry. The original attempt by the Trump administration said, we're going to ban transgender people from the military, and that didn't go in. That was, nope, that didn't go. That was immediately challenged, appropriately so. So then their next attempt was, well, we're not going to ban transgender people, but we're going to ban those people that experience gender dysphoria. Trying to focus on the condition as opposed to the person, the status. And those are, that's that fine line that depending on, what the case is, of where those arguments are going to be.
Thank you.
Next question.
It's the sausage making of law.
Yeah.
Hello, my name is Jenny Bess. I'm a pediatric nurse practitioner in Atlanta, Georgia, in endocrinology. So I got to take over our gender clinic for young people last year. So I've been learning a lot, and I thank you for your expertise. I have a two-part question. The first is, I live and work in the South now, and given our political environment, how can we kind of best discourage our institutions from implementing additional barriers out of a perceived maybe need to be extra cautious or like not draw attention to ourselves? I'm particularly worried about this in terms of consent, parental consent for our young people to start hormone therapy. We're dealing a lot with questions around, do we need both legal guardians to consent, how to document this information, what's our legal responsibility in tracking down and verifying information and so on. And I guess I'm curious what your suggestions and resources would be, and then specifically with consent, how we might navigate that, particularly for children that don't have intact families or are probably more underserved anyway, and this may make their access even more challenging.
Well, no, it's a spot-on question, and I'm going to give you the typical lawyer wishy-washy answer of it depends, because there is no bright line answer. This is a legal issue. What are the consent laws in your jurisdiction? And the consent laws, depending on what area of health you're talking about for, non-emancipated minors, may be different in Georgia as opposed to Maryland as opposed to California. Part of this then becomes an ethical issue. What is the reasonable ethical duty that you have to the patient to provide an informed consent and to make sure that you're maintaining the safety of that patient in the face of one or more non-supportive parents or guardians? This is going to be a challenging area to go forward. And the fallback is always, the bottom line has to be the safety of the child. And I'm using child even though we're talking about older adolescents. And that's the psychological safety and the physical safety. And each situation is going to be slightly different. Until we as a society come to a resolution on the question, it's always going to be murky. And the other thing too, when it comes to your organization about putting those extra barriers in place, that really relies on what's the risk tolerance of your lawyers. And I say that somewhat cynically as a lawyer, but that's really what it's going to boil down to is, some organizations are going to be very risk adverse, and that's where you're going to see much more stringent requirements of, to reduce the liability that could potentially happen. And others are going to have a greater tolerance of risk and are going to be a little bit more, or I should say a little bit less restrictive in setting up your program of how you're going to approach informed consent. Because the recognition is even within informed consent, as an organization, you have very limited control over how everything can play out. And it's that recognition that again, some people are more risk tolerant than others. And as a general statement, lawyers are not risk tolerant.
Thank you.
Next question, please. No. Can we get that mic? Thanks. Sorry, Paula. Help is on the way. Handheld is coming. Thanks for your patience.
You folks are my Saturday afternoon.
Hi, Cynthia Herrick. I'm an endocrinologist at Washington University in St. Louis. Thank you for your presentation. I use she, her pronouns. And so my question is around Section 1557 of the Affordable Care Act. we have always seen exclusions for surgical procedures and things like that. We're seeing exclusions, particularly from plans that are affiliated with employers that have maybe a religious exemption. On the hormone front, we can do things to find more affordable hormones, even if they're not covered by insurance. But what can we do, practically speaking, as medical providers to advocate for our patients for legal change so that these exclusions, hopefully go away for all sorts of gender-affirming care? And what can we talk with our patients about what they're able to do as well if they're interested in advocating in this area too?
Sure. I think like I said, this isn't something that's going to have any kind of short-term resolution. This is going to be a battlefield for a while. What I think we can do as healthcare professionals is make sure that our organizations, internally to our organizations, we're providing medically necessary care, because what we do is grounded in evidence-based practice and best practices and the lived experience of our patients. And we know that providing gender-affirming care is grounded in science, is medically necessary, and has real-world benefits to people's health and well-being. And, so internally, that's what we should be advocating for and making sure that there aren't artificial barriers to that. On the broader civic side, our responsibility is to be engaged citizens on an individual level, which means at a minimum, getting out and voting, but then also being involved in ensuring that policymakers and legislatures have evidence-based scientific information and are not relying off of pseudoscience, are not relying off of willfully ignorant and intentionally misrepresented data. We need to continuously pound on the truth. And, what is the best practice? What is the position of reputable medicine? Truth is an elusive thing, and science ever evolves. But countering that willful ignorance and the intentional misrepresentation is something that we all should be doing, if for nothing else, because our various disciplines' ethics require us to do that. When we talk with our patients, is to kind of explain to them and ensure that they have an appropriate understanding of the environment that's going on. And again, as a general statement, the transgender community is pretty savvy. Most people in the community have a much higher understanding of health and the broader environment in which health is delivered than general populations. But it's to explain what the challenges are and how you can navigate those challenges in partnership. Now, I do have to give you the legal thing. Don't ever do insurance fraud. You don't want to do something that's going to get you sent up the river. I'm a nurse by healthcare discipline besides being a lawyer. There are ways to navigate that ethically, appropriately, legally. That's where you have the conversations of, hey, we need to approach it this way because here's what the ramifications are. And it's going to be a fight.
All right. Thank you.
Thank you. Next question, please.
Is it on?
Is it on?
Can you hear me? Okay, cool. I'm Rebecca. I'm a nurse practitioner in Philadelphia, and I work with young people, and I kind of want to piggyback a little bit off of that for a more specific question. For my patients who are on parents' insurance, now that they can be on till 26, who maybe are estranged and cannot get off their parents' insurance without the parents deciding, and maybe they don't have the economic capacity to pay for copays, for therapy, psychiatry, pay for their medications. Is there any way that we can help them advocate in a way that is reasonable to get off their parents' insurance so they can apply for state Medicaid and get the services they truly need?
Do you know a legal route?
Yeah. I was going to say, I mean, the short answer is yes. I mean, there are reasonable ways to advocate for that. It may require obviously some structural changes. It requires state Medicaid plans to make sure that it's an affirmative obligation under the state to cover medically necessary gender affirming treatment. That the criteria that makes one eligible for state Medicaid programs doesn't create additional barriers that have a disparate impact on the transgender community. I mean, those are some of the things to advocate for. The situation that you describe is unfortunately not uncommon.
Yeah.
But as long as people are going to have to rely on a broken insurance system, these are the challenges that are going to come up.
So is there, so basically just going through the court system with your local, like, community legal services is probably the only thing that we can do to help them. And there's also like a power dynamic, right, where these parents are getting health information. So is that the only kind of way to do it?
I mean, I wouldn't say it's through the courts.
Okay.
In the United States, particularly at the federal level, the courts are not an avenue for progress. I would not bank on that. I think it's more of that. It's not so much court interpretation. It's the legislation and the policy.
Okay.
Oh, okay.
It's how do you change a state's insurance regulations that says that, and I'm doing this off the top of my head, that a 26-year-old who remains on their parents' insurance, their parents do not have the right to interfere with access coverage after age 18. Something like that provides a very clear protection for that 18 or older person who must stay on their parents' insurance for economic, whatever the reason is, but it limits the parent's ability to interfere with that relationship. That again, that's just off the top of my head, potentially go look at that, and I have no idea what some of the challenges are for that.
Thank you so much.
Thank you. And the last question, and we have 3 minutes and 24 seconds left, Paula, just so you know. FYI. Dan Metzger.
Hi, Dan Metzger. I'm a pediatric endocrinologist in Vancouver. I just wanted to point out a group of people who I think are probably underutilized and who are great advocates in addition to our medical and legal folks, and those are hospital ethicists. And I think every child's hospital in North America, I'm sure, has ethics groups. And you may have a risk-averse hospital, but when they find out that they're not providing ethical care for children, they're going to have to change their tune. And we have used our hospital ethicists we haven't gotten lots of pushback in our hospital, but going to court and having said, we have discussed this with our ethicists. Our ethicists told us this is the ethical thing to do. The ethicists also make us come up with reasonable, straightforward answers to the questions that we might get, like, have we thought about this? Have we thought about the parents this? Have we thought about the child's this? Have we thought about the down the road stuff, the ethical things that medical and legal folks don't always think about? So I think that's another, to answer the question about how to get your hospital on board, take a case that they're saying no to and take it to ethics. They'll change their tune. Thank you very much for your talk. It was amazing.
Oh, thanks. Yeah, I will definitely second that. Is that to involve the organization's ethicists in the discussion, because they can be really, really great allies. Again, I'm going to put on my other hat and be a cynic on the other hand with my 2 minutes remaining. Is again, in the United States, depending on what state you're in, the percentage of hospital beds that are affiliated with religious-based organizations can be very high. It's about 17% nationally. The last numbers that I've ever went and took a look at, and that runs into the problems of medically necessary, even ethically driven care being prohibited because of the religious affiliation dogma. And this is an area where you are seeing lawsuits of organizations that are of religious affiliations that have denied gender affirming care to folks being taken to court. And again, this gets back in that whole area where the the battlefield is set up as this fight between what religious liberty means and what it means to provide care to the LGBTQ plus community in a non-discriminatory way. Because the argument is, my religious liberty means that me having to abide by these this non-discrimination is impairing my free exercise of my religiosity. And I say religiosity versus religion. For disclosure, I'm a Christian. I was raised as a Catholic. That's their interpretation, and that's what this fight is really going to be about, because at its heart, the argument is that my religiosity says that this group of people should not exist. And that's what the fight's about. And if you want to go look at the Texas Republican Party platform for 2022 and see what it says in the areas regarding the LGBTQ people and particularly transgender people, where it says that they're not going to support any validation of a transgender person's existence. That's pretty stark, and that's where the fight is.
That's not a very encouraging note to end on, Paula.
So what I'll say about that.
Happy note, please.
Yeah, is I'm going to give you a defiant note. I don't know how happy it is, but I'll give you a defiant note. Fear and being scared is not a strategy. Neither is being angry a strategy. What's a strategy is having very firm resolve. And the community is under attack. And the other part of my biography I didn't share is that I'm a Naval Academy graduate and I was a Navy officer long before I got into healthcare. So, being defiant in the face of the enemy is not something that's unfamiliar to me. It's going to take a lot of resolve. It's going to take a lot of resilience. It's going to take a lot of mutual support to stand firm under these attacks. And that's what we have to do. We have to do it with a clear strategic eye. And that means banding together. It means being strategic in how we challenge policy, how we advocate and make persuasive arguments. You're never going to change the opinion of those who are absolutely opposed to any kind of support for transgender and gender diverse people. Don't waste your time. But that's not the majority of people. And together, we are going to get back to making progress, no matter how bleak it looks now, as long as we never give in and we never surrender. So how's that for being...
That's a great closure. Thank you so much, Paula. I miss you being here, and speedy recovery. And I welcome you all to the break for 15 minutes, and then we're going to come back and do multidisciplinary cases. Thanks so much. Thank you, Paula.
Take care, everybody. Have a great conference.